Friday on whether we think this is a good or bad idea. Our concern, as always, is based on our philosophy that there needs to be sufficient accountability for whatever profession, and that accountability needs to match that of the importance of the profession or the risk of the profession. So we have worked with both sides of this issue for years now, and have been continually impressed with the heartfelt concerns on both sides, and continue to feel that way, and will continue to work with them. Our concerns at this point are limited to a few provisions in the bill, on page 13, about some privileges and confidentiality in section B, and then page 5 about some board immunities on in section G that don't match up with some of the very complicated board issues that all of you all have been dealing with this session. But then our primary concern as the bill moves, if it does, would be, again on page 13, the section A, regarding what standard of accountability would apply to this profession and how it would relate to the standards of accountability in the professions that will obviously relate to this profession. Obviously, we all know, and I've talked about, some of these births will end up in the hospital, and how will that be governed? That's the main issue we have worked with these groups on, and will continue to monitor. And thank you for your time.
Questions? Mr. Hall?
So would you please tell me what are your recommendations as you go through these different issues that you have to come with recommendations that would address the concerns that you raised?
Primarily would be to work through the process, but specifically, we would, on the first one, section G, page 5, want to make sure that that language matches.
Section what?
Section G on page 5, under 34-1912. We would like to make sure that that language mirrors the same issues with all the boards that we've been dealing with this session, and quite frankly, Representative, I'm not our group's expert on that board language. I just know that we have some concerns about the broad nature of that community compared to what we've been working with on the dental board and the medical board and all those other boards.
Okay. All right. So you look at this mainly is a language. From your perspective, it's a language issue.
Yes, ma'am.
Okay. All right. Next one.
Page 13, the easiest one, starting on lines 21 through 23. We generally have some concerns, as y'all have heard us voice continually, over any confidentiality that wouldn't apply to other people on the same footing. Now, the reality is the medical community already has a similar privilege that is given here to the midwives, but we just generally oppose those, whether they exist or not. So we would like to work with other groups to at least match that privileged language to what's in the Medical Liability Act, or take it out, quite frankly. But we're willing to work and hear both sides. The biggest issue for us is right above that, lines 10 through 15. We have worked with the midwives on this language and appreciate it, and feel comfortable with it, with one exception based on what is missing, which is a clear definition of how their accountability would be governed. Would it be under the normal standard of common law negligence, or would it be under the higher standard of medical negligence? And would really defer to sort of the judgment of the committee and the legislature if there were concerns about the difference between, say, a certified nurse midwife with more training and a lay certified midwife. Then perhaps the nurse midwives could come under the Liability Act, and the lay midwives could come under regular common law standards, so that you sort of match the accountability level with the level of training, for one idea.
Am I clear in understanding that the common would match the two, even though they're separate in terms of the body of the group that they approach, really have basically the same meaning? Is that what I'm hearing you say?
Well, I think we would not have an absolute firm position on that. We would wanna work with both parties or both sides to make sure we thought it was fair. But I'm just saying, one idea could be, if there were concerns among the committee of the legislature that the lay midwives didn't have the same training as a nurse or a doctor, perhaps we wouldn't include them in the Medical Liability Act. We would just put them under common law liability standards. But then those that do have the extra nursing training perhaps could go under the Medical Liability Act. But our real concern is just to watch it as it moves and work with both sides because we don't want to involve ourselves in the, is it a good idea or a bad idea fight. We just want to make sure the accountability is appropriate. If the legislature decides in its wisdom that this is an appropriate thing for the state.
But we do see at this point, we have a good idea and a bad idea. As you listen to the discussion even this morning, you have a good idea and a bad idea.
Well, sure, and I mean, I have personal feelings on that, but as an organization, we're trying to stay out of that